and thank you for joining the Together We Care lecture series. Before I introduce tonight's speakers, I would like to mention that this event is being recorded. However, the question and answer period will be cut from the recording for confidentiality reasons. Tonight's speakers are Stephanie Geller and Matt Del Vecchio. Stephanie Geller is a clinical social worker and team lead for the psychosocial assessments for Lianas Senior Transition Support. Matt Del Vecchio is a certified professional consultant on aging, CPCA. He is the owner of Lianas Senior Transition Support and the Psychosocial Assessments, a family-run business dedicated to providing support for families and their loved ones through the aging process, navigating their life transitions. He is also the host of a weekly radio show called Life Unrehearsed on CPCA 800. Before continuing, we would like to remind you to please mute your microphone on Zoom, and that if you have any questions, you could either write them down in the chat box on Zoom or wait until the end of the event to ask them directly. And now I'd like to invite Stephanie and Matt to start their event.
All right, Caitlin, thank you very much for the nice introduction, and thank you for joining us this evening. And we're very honored to be asked to present this presentation about psychosocial assessments. It can be very confusing sometimes, a little overwhelming. And so Stephanie and I are looking forward to presenting you with this presentation. As Caitlin mentioned, I have a weekly radio show on CJD 800. It's every Saturday afternoon. It's called Life Unrehearsed. And we just talk about all those things about life that's unplanned that happen to all of us, and more importantly, how we cope with those events. And whenever we talk about notaries and power of attorneys and homologation, it gets so confusing, and we always tend to get more listeners during those shows. So we're very pleased we could try to bring a little bit more information to you and see what we can do here at the end with some Q&A. So here's what we're going to cover here. We're going to talk a little bit about protection mandates. We're going to define all these things for you. Tutorship, what is homologation? Stephanie will then take over and get into details of the actual psychosocial assessment process, and then we'll open it up for some Q&A. So just some brief definitions, because it could get confusing at times. What is a protection mandate? Essentially, it's a document in which a person expresses their wishes and names one or more trusted people to look after their person and their property in case of incapacity. So why is it important for all of us to have protection mandates? What we're doing is we're saying, okay, while I am not in capacity, I am telling a notary who would usually notarize this, or a lawyer, I am telling who will take over my affairs if I become incapacitated, or the term might be inapt. Because if we don't have that, what happens is the courts and the government take over those decisions. And sometimes that is not a very good position to be in. So we encourage everyone, as we age, to get a protection mandate in place so you could be in control over who is going to take over your decision making should you become inapt. So that's a protection mandate. Moving along, if you don't have a protection mandate, there's tutorship. And there's two types of tutorship. One is tutorship of a minor. So this is basically a tutorship to the property of a minor. It's a legal measure aimed at safeguarding and preserving the property of a minor, pardon me, we'll go back there, until they reach full age. So tutorship of a minor is if you are a parent and you have, let's say, a special needs child with autism, for example, and you need to take over some of the decision-making powers of that individual, that's called tutorship of a minor. Where we get involved a lot, Stephanie and myself, is tutorship to a person of full age. Why would you need a tutorship? Well, unfortunately, not everyone has a protection mandate. They just didn't do it for whatever reason. If you don't have a protection mandate, then you need to go through what's called a tutorship to a person of full age. And basically that's a legal measure aimed at ensuring the protection of the person, the administration of their patrimony, and the exercise of their rights It is established by the court in the event of the person's incapacity and when they require representation in the exercise of their rights. So if you don't have a protection mandate, it's actually the court that will be making that decision. But by going through tutorship, you are taking a little bit more control, because there's some things like what we call a tutorship council, which could be family members trying to exercise their rights in the best interest of the individual. So again, the message is you can avoid tutorship. It's a longer process. It's more administrative. It's the courts deciding. This could all be avoided if you get a protection mandate in place. And Stephanie will also be talking to this as well, but I wanted to talk about, tutorship to the property, tutorship to the person. When judgments are made, it's these two issues that are dealt with. To property means, can the individual make the right decisions regarding property? Can they pay their bills? If they had to sell their house or their condo, do they have the capacity to do that? Can they maintain the house? So this is to property, examples of that. And when it's tutorship to the person, can the individual take care of themselves? Are they able to take care of themselves? Can they take their medication properly? Can they live on their own? Can they be okay by themselves? And that's called tutorship to the person. So this is what is being established when we do these assessments. Now, we hear this word homologation of a mandate, and that could be a little confusing. It's a strange word. This is what it means. Essentially, it's the process of having a protection mandate take effect. That's called homologation. In other words, you're getting a judgment from the courts. So if you have a protection mandate in place, fantastic. What you're saying is, if I am no longer inapt, I will assign as a mandatory, or a person that will now be responsible. It could be my spouse, it could be my daughter, my son, but you are assigning a mandatory. You are assigning someone to do that. Wonderful. Now you have it in writing, it's notarized. What happens if now I actually become inapt? Well, now you have to execute that mandate. So the fancy word for executing or making it come to fruition is called homologation. Okay, so there's a homologation process, and this is what we're going to talk a little bit in detail. So in order to get a judgment with homologation, there are two very important assessments that need to be provided to the courts, usually by a notary or by a lawyer. There's a medical assessment, which is done by a doctor, and a psychosocial assessment, which is done by a clinical social worker. Those two assessments are crucial and required by law to present to the courts in order for a judge to make a decision. So we're going to get into a little bit of the details. This is quickly just a lot of words in this, but a medical assessment, it's about 7 or 8 pages. It's filled out by a doctor that will assess the individual. At the end of this assessment, you're essentially, the doctor is saying, is this individual apt or inapt to person, and apt or inapt to property. Okay, so that is the conclusion of the medical assessment, which again is done by a doctor, usually a GP or a geriatrician that will, or neurologist that will fill that out. What we do as an organization is the next one, which we call a psychosocial assessment, which needs to be completed by a clinical social worker. So Stephanie is our team lead for psychosocial assessments. She's a clinical social worker, and this is exactly what she does. So she does it herself, and she is also managing our team of social workers. So I'm going to throw the floor over to Stephanie, and at the same time, I'm going to pull up an actual psychosocial assessment. This is what actually has to be completed by the social worker. So Stephanie, I'll throw it over to you, and we'll go through this kind of page by page, okay?
Great. Thank you, Matt. I'm going to add 2 quick things, if that's okay, before we go through the psychosocial assessment, okay? Excuse me. The first part is the homologation piece that Matt Del Vecchio was talking about is really important, because What a lot of people say to us is, oh, don't worry about it, I have a mandate. And we say, well, that's great, but have you had it homologated yet by the courts? And they say, what? They don't realize that having a mandate is a great first step. However, going through the court system and having it homologated, otherwise known as activated, is what starts the process. You can't just have a mandate without the homologation process. The other important thing that I want to just reiterate, and we're gonna see it in this presentation, the psychosocial assessment that we're about to talk about has a lot of the same questions, not as medically based as the medical assessment that's done. And what you will see throughout this, I might be jumping a bit, is that at the end they want the opinion of the social worker the same way they want the opinion of the doctor when they do the medical evaluation. And what you're going to see, I'm going to wait to get there because I don't want to jump too far ahead, is they want to see, is there a agreement between the social worker and the doctor in terms of if the person has shown signs of not being capable of taking care of the two sections that Matt was referring to, which is a capacity for a person and capacity for a property. It's when they doesn't always match that the courts sometimes turn around and go, interesting, you guys are kind of seeing this a little different. Let's kind of, let's figure out where this miscommunication is happening. I'm going to show you what that looks like as we go through it. But for now, this is what a psychosocial assessment for a protection mandate looks like. And we're just going to, I just want you to get a feel for what kind of information they are asking and then how we kind of go about that, okay? So this is page 1. And this is general information: person, male or female, where do they live? Do they have a phone number? Do they a mobile, etc., etc. We also have to provide one piece of identification that you'll see right now is in bold. It says mandatory proof of identity. So they want to see, in fact, that you have a birth certificate copy or another proof of identity. So that would often include like a RAMQ card, your Medicare card, and it has a picture, so that's great. This is the section that I usually don't have a problem with: the names of people's parents. As we know, people with dementia often are able to remember their long-term memory, so the names of mom and dad are usually easier to retrieve from them. Language, legal status, and then they just ask if they're part of a Indian nation. Section 2 here, thank you, Matt. Section 2, general information. So single, married, here's where it gets a little funny, because what they want to know is, yes, the person might be single now, but if they were ever divorced, even if the person is not part of their lives right now, they still want the name of that person. Are they in a common law? Great. And then circumstances. So what are the circumstances motivating the assessment? So this is where we would just kind of write a little bit of information, some checkoff, and at the end briefly state the circumstances motivating the assessment. And that's our opinion. Something's happened. Mom, a mandatory needs to sell off a piece of property. They're concerned about capacity issues, and therefore we are going ahead with this psychosocial assessment. Great. The next page, again, just general information. They just want to know, usually on a mandate, a person will identify a mandatory and even substitute mandatories. Why? Well, what if something happens to the mandatory, that they pass away, they become ill, and they don't want to take on that position? So if there is a substitute mandatory, that person may be called to step up. If there is not a substitute mandatory, then we either see if there are other mandatories. If there aren't, we go straight over to tutorship, which is a different game. Okay. Visits, date of meetings, just as he's passing at the end of page 3. How many times have you met? I personally like to meet with people at least twice to make sure that each person is representing in the same way and that I didn't just catch them on a bad day. Okay. Page 4. Okay, so who did I speak to? We're going to talk about that. You have to confirm the information as well. Who did you speak to? What is their relationship to the person, the date of consultation? And then section D, there's a bunch of reports that are going to go along with this application, which includes the medical assessment. There's usually an affidavit or a letter of confirmation that is written by a notary, if not a lawyer, and you're just writing down that information, okay? And then section 4, this last part here, where does the person live? Are they at home? Are they by themselves? Are they in a residence? Are they in a CHSLD, which is the French acronym for soins longue durée, long-term care? Okay, that's the end of page 4 there. Okay, page 5, is there any legal proceedings that are going on with the person now that we should consider, because this is going to the courts? Section 6 is where it starts a little bit more of the story. What is the significant psychosocial history related to the incapacity? You'll see one of the questions we're going to ask at the end, we're going to address this. The question is, how did this come about? What's the history of the person? How did you start to know that this person was decreasing in either their mental or physical capabilities, and the reason that you're filling out this application, okay? This continues, this keeps going, and then the social rules and responsibilities carried out by the person, if they are able to. Sometimes they're not able to. Okay, and then there's maltreatment. This section is what the courts want to know is there any reason for you to believe as an evaluator that this person is being maltreated, abused, or exploited in a different way? Usually the answer, at least we hope, is no. There are times where we get a yes or a maybe, and then we explain exactly what the situation is that may be taking place, as well as who gave us this information, and has it been taken any further? Meaning, have you filed a police report? Have you spoken to an accountant if it is financial abuse, so on and so forth. So this is your chance to explain the situation, etc. What measures have been taken, if there's anything. So for example, if it was financial abuse and they're talking about a financial institution, has there put a stop on their payments and so forth? So they want to get an information on that. Now, section 7 is actually a lot shorter than what it used to look like, because all they want to kind of get a glimpse is money in versus money out. Now, what that means is, could a person pay for wherever it is that they're living? If they happen to be in a residence where they are paying, don't mind the numbers, $3,000 a month, could they afford it? What are they getting from the government, perhaps, that will help them to pay for this? This is old age pension. This is supplement, OACs. This is RIFs. This is RSPs, tax-free savings, etc., etc. We put as much information as we can. Sometimes the family does not want to divulge information, in which case we would say, family not willing to share information. And that's up to the courts to explore it if for some reason they felt that there was some financial abuse going on. Okay. Number 8. So these are questions, they're just prompting the evaluator to answer questions. How do they participate in decision making? So you might go into a nursing home and you might find somebody who is earlier in the disease. Okay. So that's to say dementia. And if they're earlier in the disease, it might be that they're just forgetful. But just because a person is forgetful doesn't mean that they can't participate in decision making. So the question is, does the orderly, does the healthcare worker say to them, would you prefer to have orange juice or apple juice today? Do they give them, or do they just put it in front of them? This is your opportunity to kind of give a picture of if the person is saying that they are participating in decision making, or if in fact they're not. State of mind, all of that. Are they willing to offer help? Okay, all of that will all depend on the assessment that goes forward. Faculties of the person. So to what degree is the person able to administer their property? We're talking a little bit more about, could they exercise their civil rights? Could they be an independent person within society and be able to still go to the bank and pay for a small bank, their TV, their phone, their whatnot, or do they actually in fact need help with all of this? Okay, what is the person's concerned opinion about homologation of the mandate? Well, this is your chance to say, well, either they're okay with it or perhaps their dementia is further declined and they're not able to respond. So it's up to us as evaluators to say things like, person is not able to recognize what a homologation of a mandate means or what it entails. Okay, that's that section. Were people consulted? Yes or no? We go ahead with that. Who was consulted during the process? Are they all in agreement that the people who have been chosen as mandataries, when a person in fact was apt and was able to make their decisions, is everybody in agreement that person X, Dan's wife, is Dan's wife the right person to make all of these decisions? And this is your opportunity to say either everyone's in agreement or, well, there is somebody who's kind of coming forward and contesting it, in which case we would just write a little bit about what's going on there. Okay. Wonderful. Now, section 11, opinion of the assessor. So that's, the assessor is me. What is the opinion of the assessor? I want to give a good feeling, a brief summary as to what happened and what is the person's incapacity. This is where we need to get a little bit more into the nitty gritty. So we will use words like a person is unable to take part in their ADLs, hard word, ADLs, activities of daily living. What that means is a person is able to tie their own shoes or do up buttons, but is not able to take a shower on their own. Or a person needs constant cueing when they're in the shower. Please use the soap on your body, etc., etc. So we really have to paint a vivid picture of what the person is dealing with in this section. Thank you. And this is the section I was talking about, the opinion of the assessor. Is the person, do you believe, in the conclusion, incapacity to a person and to the property? In other words, if a person does have dementia that is further away, further gone, if you will, and they need somebody to make decisions on their behalf, then I would say yes, incapacity to the person. Incapacity to the property, again, the way Matt said, could they sell a property? Could they go to the bank and pay a telephone bill? If they're not able to do these types of things, then again, you're going to say yes, incapacity to property as well. And then you're just going to write the information, the mandatary's name, and if everything's okay with that person being chosen, maybe there might be a few mandataries that have been chosen in this case, or substitute mandataries. Any urgent need to intervene with this measure. Now, what the courts actually mean, and a lot of people get confused with this, they don't mean, oh, guess what? We have a piece of property that needs to be sold now. That's not what they mean. They're looking more for information like, is the person being abused in their home or by someone who's taking care of them? And we need to speed this through the courts as quick as we can. So that's the kind of information they're looking for there. Great. So this was just general information on the interview, your recommendations. Usually we would say we would like to go forward with homologation of the protection mandate, things like that. Whether the person concerned of the assessment has any requirements. So that they mean something like, well, the person doesn't talk much, or it needs to be prompted to speak, and therefore having a daughter or a son around during the interview might be beneficial for it. Okay. And number 13, this is the end of our section. What is my name? What is my order number? Am I the person who in fact is going to be responsible for the case, or have I just been hired through, for example, Lianas services just to do this process, and going forward the person might be in a residence or retirement home known very well to a CLSC, or now called the CUSs, where there is another worker who is going to be involved and caught up in the event, because it does take a little bit of time while it's waiting for the court. That person should be identified, okay, at the end, to let them know what the court hearing has shown. The next few pages are just examples for us. How do we fill out certain information? And that's what it looks like. That's what a mandate looks like. I'm going to suggest we probably leave questions to the end. Great. Excuse me. One of the big questions that comes up is, who needs to be interviewed for this? So obviously we need to interview anybody who's been named as a mandatory for this file and or substitute mandatory. We always like to get the opinion or the interview of different people to find out more about the person. And when possible, if we can get a non-family member as well, like a nurse worker, a memory care manager of a residence, or somebody else, even a doctor, if we can interview them and get some information as a non-family member, just to make sure that there's no collaboration from the family trying to give the information. We want to make sure we get it from all different areas. Okay, so these are the people that need to be interviewed. What information are the courts looking for? Well, here's the thing. They are looking for a picture of a timeline. So the questions where it says brief history of the incapacity, we know how to word it in the sense that they're looking for a picture, and the picture will look something like this. When have you started, or what have you been told as the assessor of this paper? What have you been told in terms of when the family or whoever it is that are the mandators for this case, when have they started to notice some dementia or some loss of cognition or loss of things like that? And then you talk about the evolution of how things took place. When did it start? Did it start 1 year ago? Did it start 5 years ago? And where are we now? How is the person presenting now? So you really want to be able to explain what that timeline looks like. The other thing that we're talking about is the other thing they're looking for with courts. Why are you applying now? What made you decide that now was the right time to homologate the mandate? Sometimes it's a doctor that says, you know what, this is the time. Or here's what's interesting, COVID-19. A lot of people found during COVID, they did not see their family members, possibly for a couple of years. And then when they saw their family members, they realized there's quite a big decline. So they decided that they would get in touch with perhaps a doctor or other people and go ahead to homologate this form, okay? Excuse me. The courts are also looking, and this is something we talked about before, are there any signs of abuse? Usually financial abuse, maybe neglect, physical abuse, emotional abuse, verbal abuse. Is there anything that the courts need to notify or be notified of that they need to consider in this court mandate? Okay, and the last question here, how we actually go ahead and word it. Now, we know as social workers, private social workers, that the courts are looking for certain words and certain terms. So we need to be a little bit, careful how we word things. Like I said before, ADLs, activities of daily living, those are words that they would use. What are ADLs? Person's dressing, showering, sleeping, laundry, housekeeping, all of that stuff. They want to know, how does a person take care of that all by themselves? This becomes the daily living is what they're referring to. Another thing that we use in terms of words, for example, if I was referring to myself, I could call myself either an evaluator or an assessor. Sometimes we use the word undersigned. Okay, these are the words that the courts are familiar with. And excuse me, the other thing that we have to word very carefully, it's not often that we're asked to do these types of assessments virtually. That usually only happens when you're not able to get to a person, either because they live in a remote area. Perhaps they lived in Quebec at one point, now they're living in just, for example, Ontario. So that would be a meeting that we would do virtually, but we have to be very careful to word it because we need to explain. It wasn't just a laziness on our part not wanting to go visit the person. We needed to explain that the reason we did it virtually was because a person is not in front of us for multiple reasons, and that we confirmed that the information was accurate, usually by speaking to a non-family member who was able to verify certain information. So we need to protect ourselves. We also need to protect the person that we are in fact doing this assessment for. So these are important things, okay? I think that's it for that piece.